Hello, everyone. Welcome to our AI Governance Live Talk. Today, I'm here with Philipp Hacker. Welcome, Philipp. I'm so happy to have you.
Hi, Luiza.
Hello. And this is the 24th edition of our Live Talks. Our topic today is AI compliance challenges, liability, transparency, and fairness. Professor Dr. Philipp Hacker, he holds the chair for law and ethics of the digital society at the European New School of Digital Studies at the European University Viadrina Frankfurt. His research focuses on the regulation of digital technologies, particularly concerning AI. He received several academic prizes for his work, such as the 2020 Science Award of the German Foundation for Law and Computer Science. He's also a member of the Task Force AI Governance for the German federal government and co-chairs the working group on AI liability for the European Parliament. We're going to talk about that. And he's a star. For those not aware, he's publishing nonstop. So if you check Google Scholar for his name, you'll see nonstop. And I don't know how he finds time to write so many interesting and in-depth articles. So welcome, Philipp. I'm so happy to have you. It's going to be an exciting conversation.
Thank you so much. This is all flagrantly exaggerated, of course, but thanks so much for the kind words. And I'm really happy to be on your program, Luiza. It's long overdue that we talk to each other more. So this
Absolutely.
is great.
I was telling Philip that we could probably be hours talking about AI compliance challenges. So this is
That's
our
probably
topic.
correct.
I have some hot questions to ask Philip, but before we continue, if you want to stay up to date with everything AI governance, so subscribe to my newsletter, luizasnewsletter.com, and also to receive updates on the next AI governance live talks. Also, the next cohort of my AI governance training, so the April cohort sold out, so the next one is May, so 15 hours. So if you want to listen to my voice over 15 hours live with me, so May, starting in May, you can register. The website is under my name, aitechprivacy.com. You can register. So let's get started. So let's start with the hot topic of the moment, liability, AI liability. So for those not aware, so I will have some quick introduction. The AI liability directive was withdrawn. And why it matters? So the EU has the EU AI Act. Everybody knows it. So it's the first comprehensive AI law in the world. But the AI Act does not cover liability. For those in the audience that are non-lawyers, so what does it mean in practice? So liability has to do with when harm occurs. Let's say that an AI system causes harm to a person. This person, I don't know, it's injured or any sort of harm. So psychological harm, discrimination, you can think about fundamental rights harm or physical harm. So the person is dead, any sort of harm. It will occur regardless of how perfect the law is or the AI Act is. There will be harm. So the AI Act does not deal with liability issues. For example, what's the causation? What is the cause of this harm? Was it the AI system? Is this AI system defective? What are the rules for compensating the victim? So all those typical liability rules, they are not specified in the AI Act. So the AI Act does not deal with that. So we still need something else. We had a proposal for an AI liability directive, which Philipp Hacker was directly involved. So he wrote an in-depth impact assessment. So we'll talk more about that. Just an introduction. So this proposal was withdrawn. But then, Philipp, I want to start with this aspect. So I read yesterday in Euronews, there was a news website, that the European Commission will decide whether to definitely scrap its planned liability rules for AI in August. So we are in this gray zone. So you are directly involved with this process. I would love to hear from you. So what's really the status? First, what happened? This withdrawn thing was a political decision, was a legal decision, was pressure from the AI summit for JD Vance, made everybody scared, and then they withdrew. So what's going on?
That's a good question. Now, I'm not the commission, but here's some things that I've heard and I can share, and that also makes sense to me. So first off, I do not think this was a direct reaction to the AI summit and to JD Vance's speech, for whatever it's worth, because this was part of the Commission work program, right? And the Commission work program is something that is a long time in the making. Now, for a long time in the making, we have had also calls for a simplification of the EU digital regulation and agenda. And it's something that I absolutely share. I mean, that there are all these digital trackers, and then you have meta trackers, trackers of trackers. It's just crazy complete. Kite Center has one of them. It's not only the AI Act and liability, it's Data Act, Data Governance Act, you name it. So many different rules, and they are not well coordinated, and that creates a problem, particularly for SMEs. And hence, I absolutely welcome the idea of simplifying that and streamlining it, and making sure it can be implemented. But it also meant that the Commission was looking, I guess, for some easy ways out to signal both to VCs and the AI community, but also now to an international, say, landscape that's more hostile to regulation, that they're doing something. And the ALD was kind of an easy target because it was stuck anyways. There was a very vivid process in the European Parliament to kickstart it. And actually, that had already started. So I was giving a presentation, and actually I gave one at the end of January there to kind of be cross-examined on my report. That was a cool experience. But I think it became kind of one of the easy things to withdraw, where people thought they could cut red tape, they could have a good narrative, and they wouldn't hurt nobody. Now, it turns out that I think that this was just the wrong instrument to choose for scrapping. Why? If you want to cut red tape, then don't start with liability, because liability is not really red tape. Liability just says there's a harm, you got to pay. If there's no harm, it doesn't really matter what you do. It's just up to the companies to design the best compliance structures for them, the most effective and efficient ones. What is creating red tape is much more the anticipatory or direct regulation of AI in the sense of the AI Act and other rules. So if you want to cut red tape, that is, I think, the wrong place to start off with. Plus, as you already mentioned, there are harms with AI systems. Now, I'm a big fan of AI generally, and I think we need more of this in the EU and worldwide for many reasons, and for many of the big problems that we're facing on this planet, but certainly only AI that is done in a responsible and sustainable way. And to make sure that this is the case, we need certain rules for certain harms. Now, in the EU, we have a new product liability directive, and this is certainly something we will come back to during this talk. The product liability directive kind of sailed in the shadow of the AI Act. So the AI Act was the thing everybody was focused on, but actually last fall, the product liability directive was voted into law as well, and it will kick in, it will become applicable at the end fall of 2026. And that will apply to AI as well. So now you have the product liability directive, and people said, like you say, oh, we have the product liability directive for AI, plus we have member state law. So what do we need the AILD, the AI liability directive for? And they have a point in this, but the product liability directive only covers certain types of harm. It only covers harm as long as you have physical harm. So basically somebody dies, run over by a car, or gets physically injured, or also mentally injured, like psychologically injured. Or if you have consumer property or consumer data that is lost or corrupted. So if an AI system goes awry on your computer and all of a sudden deletes all of your vacation pictures, then you can sue under the PLD. If that same AI system in a racist way discriminates against you or hurls insults at you, there's no way you can have recourse under the PLD. In the EU, we have member state law for that, but we have 27 of these different member state laws with very different procedures, with very different rules. And the problem is that both for consumers and for companies, that's not a good way to handle this, because the ML systems, they're rolled out in the entire EU, effectively globally. And now companies have to contend with, these different patchworks of systems. So it was not good for innovation either, I think, to scrap the ALD. So long story short, it was scrapped. But then the European Parliament, in particular, the rapporteur of the file, Axel Voss, and some others came out in a very pronounced way and said, listen, guys, this is not the way you do it. Without any forewarning, the Parliament had already started a process, had already held hearings, had already put up a stakeholder process in place. So now they said we need to reinstate this. And the Commission is kind of open to this, but it needs a signal from both the Parliament and the Council that they want to continue going ahead with this project. And as it stands right now, I do not think that this is overwhelmingly likely, because there's also internal conflicts at in the Parliament between different committees, whether this is actually the kind of regulation you want to have. I think it was not a great way to start anyways, because it was purely focused on procedure. And it did not say anything about the substance of, when is somebody going to be held liable? For example, if an AI system not only discriminates against you, you have EU rules for that to a certain extent, but if personality rights are infringed. So it's a long, complicated process. I was quite involved in it. For the moment, that expert group is on hold, and we'll see how it goes. I'm really looking forward to seeing in the next couple of months and helping people think along in the terms of, how could we revive this project in one way or another. I think it might take some time, probably more than until the summer, to come up with a new proposal for a streamlined and more coherent and universal AI liability regulation, or even software regulation in the EU.
So you think there will be a new proposal? You don't think this is something?
I think
the big one that you just said. So you think there will be a new from scratch? You think that it will delete and start?
So I think, quite honestly, I think the current proposal is almost dead. I mean, it could be revived, but I'd be rather surprised.
After I read your impact assessment, you basically killed it, Philipp. You mentioned so many. I loved your impact assessment. It's such an interesting document, so many important points. And also the first draft of the AI liability is before the AI Act, right? Before the final text, there were many things that were not compatible. So I think you're happy with that, right? You wanted a new thing.
Well, yes and no. I wanted to redesign it, but it's true. I think I have to take part of the guilt, because maybe the impact assessment was draft. Sorry?
No, just you killed it with your arguments, not that you were.
Yeah, no, but I mean, I think some of the arguments or some of the proposals that I made in that report were perhaps too far-reaching for some, particularly of the member states, who then became kind of entrenched in opposition to the file, and that maybe helped kill it in the long run. I mean, I don't know. So, anyways, I'm happy to, I'm happy to contribute to more ideas to, how we can really generate a harmonized framework, because I think that's what we really need, a harmonized framework in the EU that's simple and implementable for AI compliance and AI liability. And you know why? At the end of the day, that will make it easier for us as compliance experts and legal experts, but also AI scholars, to think hard about the right architecture for AI regulation in general. Because then you're going to have the AI Act plus a fully harmonized AI liability regime. And then the question really becomes, do we need both in all sectors? Or is it the case that we can really start cutting some red tape in the AI Act and rely more on liability in some areas? So we might talk about some of the weaknesses of the AI Act and some of the strengths later on, and that would be, an interesting comparative exercise in looking at what is the best architecture going forward to give both consumers a way of recourse and companies some legal security and way for innovation.
And some things that you said. So first, on the PLD, the Product Liability Directive, regarding psychological harm, it said, well, I think an interesting aspect. So it covers medically recognized psychological harm, which will be actually a narrow target, right? You mentioned mental harm, so it should be something, I don't know exactly. So it was in my mind. So emotional, what in a spectrum of emotional harm, it's really, so as you mentioned, so discrimination, fundamental rights harm is not covered, right? It was a big expectation from the AI liability. And also you mentioned, so the AI liability directive, from an AI race perspective, what do you think it's smart to take it out, so to withdraw the liability directive from a so to try to make the EU more competitive? If we think, so now let's imagine a company that wants to offer an AI system in the EU. So the legal team of the company will have to have in mind the AI Act, the legal framework of each and every member state that they want to offer the AI system. So beyond, people forget that it's not, the AI Act is one of the laws that will be applicable. So the whole legal system of every country will still be applicable. So they will also have to have in mind and plan for that with contracts, with whatever compliance mechanisms for 27 different liability regimes, right? So especially discrimination, as I mentioned. So probably many countries will cover AI-related discrimination. I'm not familiar with the 27 member states laws on liability laws. Some states will likely cover it properly. The system will absorb the idea of AI-related harm or discrimination coming from an AI system. Other systems will likely not cover it, right? Because it's maybe, I don't know, because the causability will be difficult to prove, or the fact will be difficult to, so it's unclear how it will look like. So that's what I wanted to ask. So from a AI race perspective, if we want to try to make the EU more competitive, this is counterproductive, no?
So yes and no. I think you have to differentiate between the substance and the narrative. What has gone awry, I think, in the EU is the narrative and not so much the substance. The AI Act, for example, I think is much better than its reputation, because in many respects, it only hardwires industry best practices for a limited set of fairly well-defined high-risk use cases and for general purpose AI. On the other hand, the narrative that has taken over is that the AI Act is super strict, stringent, that it kills regulation. Which, I mean, it does have an effect, that's for sure, but I think this is much overblown. In fact, it might actually be intentionally overblown by some actors so as to depress the value of European companies to make them easier targets for takeover. The fact is that the same now holds vice versa with the AILD. The AILD withdrawal has a positive narrative in the sense of, hey, we're showing in the EU that we're cutting red tape and we're caring about innovation. We're not regulating anymore. But on the substance, it actually makes life harder for many companies because it has these 27 different rules. Now, I see in the chat some questions around, will liability be covered for if somebody kills themselves? So yes, that's death. That is covered by the PLD. But Erica says, wasn't it the procedural rules that we might come to, later on? You have them in the PLD and they were also in the AILD. What were the two main mechanisms? The two main mechanisms were, one, evidence disclosure mechanism. If you have a plausible case that you were injured by the AI, then you can ask the company, the developer, the manufacturer, to give you the data and the algorithms so that you can find out whether that product was actually defective or whether that product actually whether somebody was at fault, and at the end of the day, that caused your harm. That is pretty far-reaching. And we know from the US that this kind of pretrial discovery can lead to real damage in the sense of competitors trying to, get information, all kinds of obnoxious or toxic litigation. And those are concerns that were taken very seriously. And hence there will be in the PLD, and there was going to be in the ALD, a limit to this disclosure obligation, of course, when it pushes up against trade secrets and IP law or IP rights. So for these, you have special procedures, you can have special masters, you can have in camera, you can have special settings in the court, confidentiality agreements, so on and so forth. So that's one angle. And the second is the presumptions of defectiveness. Actually, in the ALD, it was only presumption of causality mostly. It was very little presumption of fault. So actually, this was not so hard. But actually, a lot of industry was also quite up in arms against that. That's true. But at the same time, you often have similar rules already in member states, where if you cannot bring evidence, for example, in a product case, then it might be the case that the company who manufactured the product has to bring forward evidence to exonerate them. But these rules will differ. They were not as far-reaching, mostly, I'd say. I don't know the procedural rules of 27 member states, but mostly they were not as far-reaching as the rules that we now will have under the PLD from 2026 on, and that we were going to have on the ALD. But still, I think many companies prefer, from the companies I talk to, a regime, even if it's a little stricter, that is uniform across the EU so that they know what to deal with, rather than having this patchwork of crazy amounts of, from Romania to wherever. So that remains a concern, that the message is supposed to be positive and, we're enhancing competitiveness, Draghi report, all gears unleashed for competitiveness in the EU, whilst really in substance, that's not the case. And that of course, is also a problem with communication on the side of political decision makers, who are not always the best ones to bring across the fact that some of the rules are actually very sensible and are not as stringent as they're made to look, whilst others are perhaps much more invasive, even if you don't really look at it very closely. So I would say, for example, that for many companies, the product liability directive will be actually much more impactful than the AI Act. Why? Because the AI Act looks at, again, GPAI. So if you're OpenAI or Microsoft, Google, yes, you will be covered. But those are big companies. They don't have much problem with this, except for this being a nuisance. And high risk, which also is something that not too many companies will fall under. But if you PLD covers all AI and all software. And in fact, what's happening, and what I think is really underappreciated, is what if there is a harm from a non-high risk product? So for those who are not so familiar with the AI Act terminology, what is high risk? High risk, that would be something like life and health insurance, credit scoring, anything relating to employment, migration, law enforcement, and education, for example, and medical. So those are the main big points. So if you, for example, just do a customer management system, or you use generative AI, but just for emails or whatever, that's not high risk, okay? So many spam filter, whatever, but still there can be harm if you do that. So for example, insurance that's not life or health or whatever. And what happens then? If you have such a case, the judge will ask, well, was the product defective? There are no high-risk rules from the AI Act, but the judge will still very likely look to the high-risk rules in the AI Act and say, well, did you follow some of these rules, even if this was not high risk? Because one of the high-risk rules, for example, is Article 10, data governance. You need to have training data and validation and so on data that is appropriate for the task at hand, that is representative of your target group, basic 101 data science. But of course, only because this is limited to high-risk AI does not mean that you can do whatever for non-high-risk AI products with your training data and think that you can get away with it if there's a harm occurring. No, this is absolutely not going to be the case. So with the PLD that does not differentiate between high risk and non-high risk, the high risk rules, in my view, likely will become much more expansive, at least in the lightweight version, and expand to basically all of AI. And that's going to get much, plus the evidence disclosure mechanism and the reversal of burden of proof, that in conjunction will be much more impactful for many companies than the AI Act. Plus, if you're
on a point that you said, I think Erica in the audience was asking about chatbots. I think there's a real case. It's one of the first lawsuits involving liability and chatbots. So maybe we can have a thought experiment here, right? I'd love to hear your thoughts on that. So in the US, you probably heard of that case involving the company Character AI. So the Florida teenager was chatting with the impersonating version of Daenerys Targaryen from Game of Thrones, and then the teenager committed suicide after chatting using Character AI. And then it was last year, and his mother now is suing Character AI. So I read the initial the first piece of the process, and then I saw the answer from Character AI. Of course, the lawyers are denying, and it's US law, so it's different. But Character AI is saying we have no responsibility. It's a different legal ground. There is no AI Act in the US. It's a different legal framework. But let's imagine that something like that happens in Europe, and it's something we'll talk about some of the loopholes and gaps of the AI Act. So let's imagine that is a system that was created after August. Let's imagine that everything is in place, that the AI Act is applicable, and also the PLD is everything. The full framework for liability is applicable. So let's imagine someone is using a chatbot, and a conversation, if you look at the screenshot of the conversation, it looks like a normal conversation. There are no specific, I don't know, blacklisted works. It was a normal conversation, but perhaps more intense, romantic, and the teenager interpreted it in a way and committed suicide. Do you think that it involves death? So it would be applicable, potentially, the PLD. But then we would still have to prove defectiveness and causality, right? There is the article, I think it's Article 10, I don't remember the number of the article, that helps with the presumption. The judge can declare presumption of causality, but that's such a challenge in AI. So it's a chatbot, and you visit this chatbot to role play, right? To chat with this figure that doesn't exist. There is this warning in the interface saying everything is made up. So do you think it would be effective in this potential case? There have been 2 deaths already, suicides involving chatbots. Would the PLD cover that case? So would defectiveness, if you're having a normal conversation with a chatbot, and because you're dependent, you are 24/7 for 6 weeks chatting, you commit suicide. Would it be considered defective? I have difficulty understanding how how would causality and effectiveness work, and if there would be any different legal ground to make the company liable. What are your thoughts on that? Really brainstorming here on the spot.
Yeah, super good question. I mean, there was this case, you probably referred to that one as well. There was a Belgian guy in Belgium that's in the news that also
exactly.
And that actually there was not ChatGPT, it was a GPT, but it was one with very few guardrails, from what I know. Yeah. And so that's what it really boils down to. I think at the end of the day, I would say that the providers of chatbots, so the OpenAIs and so on of this world, cannot really be made liable for just any random acts that users make when they interact with their chatbots, particularly if there is no specific, say, output of the chatbot that would initiate or push towards such a result. That I think was different in the Belgian case. If I remember correctly, the Belgian guy even said something like, "I'm thinking about suicide," and then the chatbot replied something along the lines of, "Yeah, I'm waiting for you in heaven," or something like this. So the character replied, "If you have something like this, so first off, you need some initial grounds that would be potentially causal and that would go beyond what you would expect in an ordinary conversation, that kind of exhorts whatever kind of damage. It could be physical damage, it could be suicide, it could also be something else. And then it could also be mental damage, as I said, psychological harm. And then second, you need to show still defectiveness. Defectiveness means that you need to show that there was a design defect, usually, because it's not going to be a construction defect nor a warning defect. Now, the warning does not absolve you of curing design defects. So you can't warn yourself out of a bad product if there were reasonable alternative designs. So what, in the end of the day, the company would have to do, the company who is developing the chatbot, is document in a really good fashion the way they designed this chatbot and the security and safety layers they installed. And this is why, for example, this kind of content moderation that is now often decried, by free speech absolutists who then turn around and, shut down all kinds of accounts that criticize them. But that's a different story. So a lot of movement against what they call censorship, which is actually just making sure that there is that you reduce the probability of harm to an acceptable degree. So I think if you launch quite clearly an AI chatbot with minimal or no guardrails with respect to these kind of toxic behaviors, toxic output, and
you mean both the interface and the training, so both the fine-tuning kind of filters and fine-tuning, and also the design, the interface. So if you look at if you probably saw the interface of Character AI, I always comment on that. So it's remember, everything character says made up, and then it's in red and black. And I say you even have to get closer to the screen to see that. Is the most important warning ever. So it's interesting. So both conduct studies and document that choice, the design, both the training choice, and the super interesting.
Exactly. So the whole product itself needs to be sufficiently safe so that you can say there was no reasonable alternative design that would have enabled you to develop the chatbot in a way that is almost equally, functional or effective, but that would have prevented that harm from happening. And for example, if you like that chatbot that was used in the Belgian case, if there was state-of-the-art procedures available for security layers to make sure that certain filters are applied, that with reinforcement learning with human feedback, other types of reinforcement learning, you can get certain bad toxic output out of the way, even without, the more crude filters, because oftentimes then you can say, hey, this is just a theater play, and, you can get around that fairly easily with jailbreaks. So if there is state-of-the-art technologies to prevent this, then you generally have to use it. If you don't, then it can be considered a defective product. And then indeed, you can be liable, but not for just everything. There's an interesting case, if I may say that. It's the autocomplete case in Germany, and I don't know if everybody knows about it, but it was about actually a very famous person in Germany. It was the wife of the German president. So we have the chancellor, but we also have the president. Like in Israel, like in many other countries, the president has a more formal role. Not like in the US, it's more of a ceremonial role. But that wife, there were rumors that she was a prostitute before he met her, or that they might even have met on that way. Well, I don't want to comment on the substance of these allegations, but the interesting thing was, and I don't know, but the interesting thing was that if you typed in her name, the Google autocomplete, this was in 2012, would actually suggest prostitute. So Bettina Wolf, prostitute. She didn't like that, understandably, and sued. And the BGH, the German Federal Court for private law, it took up a different case, and there were a couple of similar cases, but it decided this one with that judgment, said, well, Google is not universally liable, but if they do not engage in appropriate mechanisms to prevent such harmful output, then they are. And what is autocomplete? Yes, it's a small language model. And so that's a case that really comes very close, I think, to our modern world. And fast forward to 2025, you have kind of similar structures. Of course, it was back then, it was not based on the transformer architecture and so on, but it doesn't matter, all these technical details. What is interesting to note is that in the Google case, in the autocomplete case, you only had Google. There was no value chain. Whilst now, as you rightly said, you have somebody who's actually training the model, and then you often have different intermediaries who are doing fine-tuning and so on, hosting, and then the user might interact with that one too in a certain way. So you would have to define responsibilities along the value chain. And that's one of the big things for AI liability going forward. And in fact, this is one of the things that were supposed to be in the revised ALD, but that's now likely at least, pushed back.
As we are now in deep compliance water, so we are moving now to I want to ask you other things about the AI, but just before we leave this topic, so I was reading all the news about the AI summit, and I saw, I think it was Macron that said that the AI Act was going to be applied in a business-friendly way, and I was so intrigued. Like, what does that mean? So it's supposed to be the opposite, right? So business are going to behave like businesses, so they will try to not comply as much as possible, but still put the budget in it. It's like to build a budget for that fine if the fine comes. So, but what does that mean? What do you think? So what does it mean to apply the AI Act in a business-friendly way?
Well, maybe it means asking for businesses to help him generate better deepfakes of himself and then promote those videos online. No, just no kidding. Did you see these deepfakes? I mean, absolutely horrendous. No, but I think what he means by it are two things. So one, that France was one of the few countries who really fought
exactly. Mistral and
against the whole AI Act, and particularly against the GPI chapter. Whilst now Arthur Mensch, the CEO of Mistral, actually says, it's quite workable, which, come on, it has always been. And those rules in the GPI chapter are absolutely laughable. I mean, it's just absolutely, except for some things in Article 55, but the rest is really, and even in Article 55 is pure baseline. This is what every responsible GPI company is doing and should be doing, with perhaps the exception of some of these companies that belong to the portfolio of the richest man on the planet. Now, what does it mean to be business friendly? I think it means two things. It means particularly to get out guidelines fast and furious so that people actually know what to expect, so they have some more legal certainty, and the AI office is certainly working on it. And second, I'm talking quite a bit also with people from supervisory authorities in Germany, also in the EU, and I think what often is a misconception by politicians is that they think if they allocate less resources to the supervisory authority, that's business friendly, because then when they're understaffed, they can't do as much. That's entirely wrong. What they are doing often is to give advice to companies. Companies come to them and say, hey, we have this case that's kind of a bit weird. Can you tell us this is okay or not? Can you kind of green light it, write a no action letter or something like this? They do this, of course, only if they have enough resources, because otherwise they really have to stick to, what they really have to do by the law, which is, enforce it. So I think primarily, I'm not sure that Macron meant this, but, what would be good is to incentivize national agencies, the national supervisory agencies, to be staffed in a way so that they can actually proactively engage with the business community and tell them, look, this is how it works. This is not how it works. You got to take this serious. But at the same time, if you have a good compliance system in place, you are, at least in most cases, fine, and you can do it and you can use it. So it's a lot about the spirit and the vibe, but it's also about being available. And then, of course, national implementation doesn't have too much leeway. So it's about sandboxes, but personally, I'm not a big fan of sand. I don't think there are going to be.
I was going to ask you exactly that. I thought it looks like you're optimistic about regulatory sandboxes, so that there's this direct contact between the company and the authority. No?
Yeah, but it's not so this is more an advice session. What they often do is a check-in session, once a month or so, where people can really a Q&A session. I think these sandboxes often it's much more formalistic. And I think that a company that really needs a sandbox is unlikely to succeed anyways, because investors, I've talked to a number of really successful startup entrepreneurs about this. None of them have been in a sandbox. They've all been, they've been in Y Combinator and whatever. So that's a big quality sign. You go to a sandbox, often a negative sign, because it shows that you can only survive in this kind of kindergarten sphere. And it makes it difficult to scale out of this. Now, if it's realistic conditions, it might be different, but I'm not so sure that this is actually going to work very well. I think for a couple of scenarios, probably, and also to just get people on board and have them try out things that otherwise they wouldn't have tried out. But I think, for the real serious entrepreneurs, I'm not really sure that they're going to need this. So yeah, I'm not sandboxes. I don't think it's going to be such a big thing, but okay.
Now I want to hear some of your thoughts on the AI Act in general before we move to transparency and bias. So first, on the AI Act, in your opinion, what are the biggest weaknesses of the AI Act, where the EU lawmaker could have done much better?
Yeah, I think overall the architecture sets the wrong focus. I think it's great that we have the prohibited practices. So, for example, very few people, and hopefully nobody in their right minds, wants a Chinese-style surveillance scheme in the EU, neither with facial recognition nor with credit scoring. Social scoring. There is, of course, a loophole in ex post facial recognition in the public sphere, so remote biometric identification, that could have been closed because we have a number of countries that are in democratic backsliding and you cannot trust them really. And quite frankly, even Germany, who knows who's going to be in government 5 years from now. So there I would have liked to see even more robust minimum safeguards against government interference with privacy, and particularly with the use and exercise of political rights, such as in demonstrations and stuff. So that's one weakness, but it's kind of a bit of a minor one, even though it's fairly significant. But I think overall, it's great to have the prohibitions. It's great to have transparency. It's great to have the GPI rules. GPI rules, I think, are much too weak, and the threshold is just much too high. We're going to see if maybe the Commission picks up DeepSeek as a first case to either lower the threshold or designate a model as systemic risk, because as some on the call might know, the threshold at the moment is 10 to the power of 25 flops, and DeepSeek R1 is likely below this. However, it has capabilities that are comparable to 10 to the 25 flop and above models, just because they
there's Annex 13, right, Philip? Also, for me,
right?
Annex 13 will certainly Annex 13 with the conditions. So DeepSeek will certainly fit one of those conditions.
Exactly. So they can designate it, but it's below the threshold where it would presumptively be considered a systemically risky model. Again, and so I think those rules are there. It's good to have them. They could have been more robust in the GPAI side, I think, well, with external red teaming obligations, for example. On the other hand, the high-risk rules, I think, could have been a little less prescriptive, giving more leeway to companies, because, for example, if you look at bias in training data, and we're going to speak about bias later, but this is an incredibly complex topic. Nobody even knows what that precisely means under data governance rules, Article 10. Plus, you have post-processing fairness mechanisms. So it might be the case that the most efficient way to get rid of a bias is not to change the training data, which also, by the way, might wreck performance, but to do it post-processing. I've actually designed 2 post-processing algorithms myself with ML colleagues. And the good thing about post-processing, and post-processing means that you run the ML pipeline. Once you got the final result, the score, then you change that score and map that, the score distribution, onto a fair distribution. There's intelligent ways of doing this with optimal transport and so on. So that might actually be the most efficient one, because you exactly know what the outcome is going to be. If you just mess around with the training data, oftentimes you don't really know what the outcome is going to be. Anyways, now you have a problem, because if you don't fix Article 10, you might be violating the AI Act, even a high-risk rule, incurring crazy fines, whilst at the end of the day, there is no problem because you're actually fixing it later in the ML pipeline. So this is one example of where I'm thinking the high-risk rules are really in need of some revision. Perhaps they're giving companies a little bit more leeway, particularly if we couple this with the robust liability system that says, hey, and if something goes wrong, then people can actually sue the hell out of you. And this is actually the much greater incentive, because for many of particularly the smaller companies, they are VC funded. So it means if they have a case brought against them, they're basically killed. So this is a super big incentive, because the VCs will just pull the money, or they won't get the next funding round if they have 1, 2, 3 not totally non-meritorious claims against them. And so I think this is where we can again see the interplay between product safety and product liability. So I think overall we might revisit some of the high-risk cases, while at the same time I think we should make sure to really look at the big guys, to have the GPA rules in place and structured in an even more robust way, to keep transparency, to treat prohibited practices. So I don't think anybody in their right mind would really scrap the AI Act altogether. And I don't think that's going to happen, frankly. But those are some of the things where we might see revisions going forward now in the new fitness check of the Commission and the simplification strategy.
And I like that you mentioned both the prohibited and the high risk. So on prohibited, I agree with you. This is one of the few provisions that I think is actually good. The social credit score is written in a way that is clear. So the legal technique and the exceptions and the way it's written is good. But if you look at the first one, the subliminal techniques, it's so bad. The language is so narrow. So at least
that's more symbolic.
We understand that they are talking about dark patterns. So my PhD research deals with that. So I'm really enthusiastic about that. But then, significant harm so many. It's written in a word with the language that it ends up very, very narrow, and then the interpretative rule is also narrow. So I read that and I think, well, I can't imagine any existing system that will fit this very, very narrow description. Our legal description. So I 100% agree with you, and I write that many times publicly, that whoever is criticizing, saying that the AI Act is horrible, is overregulated, they haven't read. They haven't. Maybe they are not legal. They don't have a legal background. Maybe they read something on the news. If you read the provision, it's like common sense. But you said something about the high risk. I want to hear your thoughts. So in the high risk, when you look at Article 6, so for those in the audience, Article 6 are the rules for classification. So the two types of groups that will be classified as high risk. So we have Annex 1 and Annex 3, basically. And there is so Article 6.3 says that even if you are in Annex 3, so that the areas that Philipp was mentioning, so education, employment, and all the sensitive areas in Annex 3, you can still, if your AI system falls into one of the four conditions, so if they don't pose a risk to fundamental rights, and you can show that with very broad conditions, then it's not high risk. And in the AI Act, in the context of the AI Act, the high risk category is after the prohibited. Okay, the worst category, the one that nobody wants to be in, is the prohibited AI practice. So nobody wants to be covered by Article 5. So okay, let's take out the prohibited AI practice. But from Article 6 to Article 49 of the AI Act is all about high risk, because the most important category. Everything that when people complain about the AI Act, they are complaining about high risk rules. Yeah. The rest is basically Article 50 and minimal risk. And if you have an Article 6 that allow, even if you're covered by Annex 3, you can, with very broad conditions, say, okay, I actually don't pose risk. So I read that and I see, as with a lawyer's head, I think, wow, that's extremely alarming. And I already see, I mentioned that in a previous live talk. So I see some law firms advertising like this. So if you are developing an AI system in Annex 3, don't worry, come here, you'll see it, we'll make sure that it actually doesn't pose a risk to fundamental rights, because the conditions, they are so broad, they're so open to design. They say, okay, it's a process where there is a human intervention before. Okay, then the legal team will sit with the developing team and they will make sure that there is a human process before. So I keep imagining all those types of scenarios that will likely be exploited. And I want to hear your thoughts. So is that on purpose? Was that by mistake, or do you agree with me? Do you think it's actually good that there is some leeway for companies to prove that they are not high risk? What are your thoughts on that?
Yeah, I think this is an extremely sensitive matter. And I think this is one of the provisions where we also that definitely are in for a revision, or at least guidelines. First off, I mean, the CJU has said a number of times that these kind of exceptions, they need to be interpreted narrowly. This is, I think, logically entirely wrong. Why would an exception be? I mean, you can phrase many things positively, negatively. I think there is no argument for that, but it's a fact. And so it will be interpreted rather narrowly. And also, I agree that some of the provisions, like, you had a human assessment before and it's only kind of reproduced or augmented by AI. It's kind of a bit weird. What the heck is that supposed to mean? But I think for many of the use cases where we would agree that this is really within the core of Annex 3, within the core of fundamental rights impact, you would not have a way of getting out of this. I would be a little bit more optimistic about it. In fact, I've worked with companies from the high-risk sector where we've sat together with the compliance team, and the compliance team and I were both saying, no way you get out of this. There's no way you get out of this, even if they would have liked to, of course, but no way. And plus, there's two things. One is you still, as you know, you still have to register your non-high-risk AI system in the EU database if you take that Article 6.3 loophole. So basically, it will still be known, and you have to list the reasons of why you think that is the case. And second, there's a very pronounced risk, because if you get out that you want to get out of the loophole, and you basically don't do any of the compliance stuff that high-risk AI systems otherwise are required to do, and then a court or regulator finds that actually you are high risk, then you're really screwed. It's a bit like I tend to think it might be a little bit similar to the concept of personal data in the GDPR, where also it might be in a number of cases that this is not really personal data, because the way in which re-identification might work, it's not really likely or whatever. But most companies that I know still assume that it's personal data, because they would be super screwed if basically they assumed it was not, and they wouldn't cover and they wouldn't comply with the GDPR. So I think that for many cases, going to be similar there. Say if you're doing anything with employment-based, decision making with AI, as soon as there is a substantive decision or a substantive recommendation by the AI system, I think there's no way you can argue yourself out of this with Article 6.3. I hope the CJU is not going to prove me wrong on this, and I'm very I'm happy to discuss this further. And I think it certainly needs more contour. But I think that generally speaking, it's right to have some kind of leeway there, because if you think about an AI system that's just doing the scheduling for the interviews, that really isn't something where you would say that has a lot of high risk potential. So that would be something where the classic admin task, or just puts the document in some kind of folder or something, even if it's related to employment, that is not something where I would think the high risk rules would be justified, and thus. I think if we can narrow it down to these really ancillary administrative tasks, and maybe take out some of these bullet points that are more sketchy and strange, then I'd be happy to keep it, but in that revised format.
No, I ask you because I know you are in the EU bubble. You are in touch. You are there, speaking with officials. So I know you have a more insider view. So I don't know. My viewers from the outside, I see the way law firms are advertising this service, and I'm like, wow, okay.
Yeah,
so
I think they're
just come here. We'll make sure that you're not high risk. Like we will get you out of the high risk category. Don't worry. So
I would like to see how they do it. I think that's probably just a bait, but well, fair enough. Yeah.
The second one that I really want to hear your thoughts. I think it's a bit. I don't see many people talking about this one, and maybe it's a major thing. So regarding the timeline, so most people, there is the AI Act entered into force, but it's becoming enforceable, and there is this timeline. So the first batch of provisions became enforceable in February, so from Article 1 to Article 5, and there will be another milestone in August 2025, and the rest of the AI Act in August 2026, but there are some provisions that will become enforceable later. And Article 111, and many of you in the audience, maybe you haven't read it, you should check it. It says that for AI systems already in the market, so everything that we have now, the AI Act will be applicable only in case of substantial modifications, meaning the exact language is significant changes in their design. So what is that, Philip? Help me interpret that. So what is this? What would be give me can you think of an example of a significant change? And when you read the recital, it refers to substantial modifications. And in my head, probably, and I hope the AI office will do that. They should issue, or the AI board later on, some sort of guideline that will say that something very small is maybe I don't know, system update, something small, so that everything that exists will be under the AI Act. Otherwise, we will see before August 2026, in July 2026, we'll see a boom, right? A major startup boom. So many people launching startup and AI systems in July to avoid.
Totally. I'm so happy you're bringing this up, Luiza, because I think it's one of the most overlooked bombshells of the AI Act. Actually, when I first saw this, I was asked to comment on some previous versions of this by national and EU persons, and I basically wrote, are you fucking serious? Like, this must be a joke. Like, really? And they kept, which, by the way, is also a gigantic competitive and undeserved competitive advantage for incumbents. Because if you are a new company, then you are fully responsible under the AI Act, whilst if you're an incumbent, then you basically get this free pass. And it's in no way compatible with product safety law, because of course it does not matter at all for product safety if the product had been on the market before or not. If anything, an existing product should be regulated even more tightly, because it becomes obsolete more probably sooner, and so on and so forth. So this is really crazy, I think. And indeed, the problem is that we have several clauses, several provisions about modifications, substantive modifications. We have Article 25, of course, where you change from a mere deployer to a provider if there's a substantive modification in a high-risk AI system. You have that. So and we have there is a definition of a substantive modification. Article 3 basically says if you change the risk profile, and that is something that I would encourage people to look at also. Basically, I guess there are two interpretations in my mind. One is almost everything counts as a substantive modification, because even if you, for example, fine-tune a system on a few data points that could theoretically change the entire tensor, the entire vector, so all of the weights and biases of the system, and it could behave entirely differently, and you would have to test to see if that's the case or not. There's a second interpretation that says, hey, here we have a modification in the design, which is something else, which is higher level. So it would be like a change from DeepSeek V3 to R1. So, or take GPT 4.0 to 0.1, like from the normal to the reasoning model, which is of course not a reasoning model, it's just calculating more. But something like this. So it would have to be more in the way the product functions, which also then has to display a different risk profile. So long story short, I think the only thing that safely where you could say that this is really not a significant modification is if you just put if you put a filter on it, for example, a new filter that is even better at detecting, say, harmful output, then I would say that post-processing filter, that would not, in my view, count as a substantive modification, because if anything, it would lower the risk profile, and it keeps the entire engine before the same. So the same, there's no unexpected cases that would come out of this that are new vis-a-vis the previous product. But everything else is really up for grabs. And the problem is that from a product safety and a general, I think, common sense perspective, I would like to see this provision being interpreted very broadly, or almost everything counts as a modification, whilst in Article 25, I think there's much better arguments for being more nuanced with respect to, whether somebody who's doing just some minor fine-tuning on a GPI model with systemic risk will then also become a provider that, has to fulfill Article 55, which really is a major problem if you are quite a competent and big company, but you do not happen to be OpenAI or Google.
And do you think that can you stay 10 more minutes, Philipp, so that we have a little bit more, or you're in a hurry?
I think, we can take like 5 more minutes or so, but then I think I have to...
So I'll skip to the last one. So I'll leave I'll skip to bias and fairness. So I know you have so many articles. I had actually a list of questions, but I'll focus on this one. So when we...
Jesus, we already spoken for an hour? All right.
Yeah, I know, right? Because I'm already skipping questions. I know we have to...
We can do a replay at one point. Okay.
Exactly. So when we look at the AI, when we look at the GDPR, and I know you also read many times the GDPR and the AI Act, the GDPR has a very important, I don't know, in my research also, I looked into it, and I think it's fascinating also from an interpretive point of view. So we have Article 5, we have the principles and the data subject rights. So we have data protection principles, and we have data subject rights, and we have seen those in play in many cases, in the enforcement cases in the EU. So fairness or data subject rights, also many applications, but I'll say here I've talked about principles. The AI Act does not have that. We do not have an article. So we have trustworthy fundamental right, the general rights, right, the subject matter article, so respecting fundamental rights, trustworthy AI, but we do not have, like Article 5, a list of central principles. Also, we do not have, so we have a very few mentions of affected persons, but we do not have like a statement. If we have the part on enforcement, you can file a complaint, but really light, or some clarifications, but we do not have like data subject rights in the same way that we have in the GDPR. With the fairness, with bias and fairness in mind, do you think that it's a flaw? That should the EU lawmaker have thought about that? And when we're thinking about bias, and in my view, maybe you have probably much more to say about that, is dealt with by the AI Act in a very narrow way, not only in a few stands, it could be much broader. So do you think that this is first, regarding the no statement of principles and rights, is this a flaw, or is this by design? Is this that's the best way? And also, how do you think bias could have been dealt with in a stronger way by the AI? So this is our last question, and then we finish.
That's a great question. So the European Parliament, actually in its position had some principles in it. They were not adopted at the end. I would have to say that I would be skeptical that such principles would actually do much work, because you have such a prescriptive system already. In the GDPR, it's a little less prescriptive. There are less rules, and hence there's more work being done at least recently, in some of the recent cases, by the principles. I think in the AI Act, it might have been even a little bit superfluous. So I'm not sure that would have helped much. I think what it would have helped much more is, and that brings us back to the beginning, makes us full circle, is some of the rights that were contemplated in the ALD. Because what you need as a potential victim of algorithmic discrimination is first and foremost to know if you've been discriminated against or not. Now, if you want to go into a nightclub, I'm from Berlin, so many wonderful nightclubs, and you get rejected, some friends of mine who are black, sometimes they get rejected and they say, this was racist. But you never know. You cannot unscrew the head of the bouncer, right? Now, that's different with AI systems. Of course, it's a big plus, basically, that you can actually look under the hood. But you need to be able to do that. So the CJU in, I think, 2012 or so, issued the Meister ruling. And in Meister, it said, well, only because you suspect that you were discriminated against, it does not give you a right of access to any of the data, for example, of other, even in anonymized way or whatever pseudonymized way, the files of the candidate that was successful and so on. So the first and biggest question is, was I discriminated against at all or not? Or was it just a coincidence or whatever? And hence, that's what you need this evidence disclosure mechanism for. And that's exactly what the ALD would have done. Particularly for non-discrimination. So I think it doesn't matter where you put it, whether you put this in the, perhaps it's systematically better positioned in an ALD style package than in the AI Act, which is more product safety regulation. You now have these small rights, but it's not really a big thing. Like to explanation and so on, but only to the extent that it's not covered for in other acts. And the GDPR right is actually now with the recent CK or Dune Bradford ruling, it's been much bolstered. Really happy to see that. So long story short, yes, I think should have been much more aggressively addressed this problem, but not necessarily in the AI Act, but more its enforcement problem for the framework that we already have. There's already a lot of EU law on non-discrimination, and it's an enforcement problem there. So we need either an enforcement directive there or a more general AI liability kind of enforcement scheme, which some of the ALD would have provided. And that's something that we need to come up with a solution or a replacement for that going forward. And it's going to be exciting to see how this plays out and how the whole architecture plays out going forward to integrate at the same time the different types of digital regimes that we have, particularly also the GDPR. And you've likely seen many of the people in the audience, Luiza, of course, knows it, that we have the kind of refocusing of the GDPR regime, particularly for SMEs, particularly maybe with the different layers and so on.
We have a full conversation only about that, Philip. So
we can.
It wasn't my list. I took it out just because to focus. Otherwise, we would stay here for hours. But we have to have another one about that. And I know Philip, thank you. I have to go now. Thank you so much. The audience will likely, so for those asking, the recording will be in my YouTube channel. So in a few, maybe next week, I will upload. So probably people are going to have to watch it again. So you shared so much valuable information. So people are going to have to rewatch. Philip, where can people find you? Where are you usually posting or sharing, or maybe?
I think mostly on LinkedIn. That's where you can find me, probably. Yeah.
Okay, so everybody, you can follow Philipp Hacker on LinkedIn, and they can hire you also, right? You're available for hire or no?
Yeah. I do consultancy, so you can reach out by email. Yeah, you
Great.
find my email address, I think.
Hire Philip to help you. Also, thank you so much, everyone, for joining, for being always so participative and asking questions. So don't forget to subscribe to stay up to date with everything AI governance. Subscribe to my newsletter, and if you want to join the training in May, so save your spot. So the April one is already sold out. That's it. Thank you, Philip, so much. It was a pleasure.
Thank you, Luiza.
And I hope we have another one. I think we're going to have to schedule another one to finish.
I think so too. It would be a pleasure. Take care, everyone. Thanks so much for the great audience.
Thank you. Bye-bye.